I'd like to once again both congratulate and commend Nalini and the Fiji NGO Coalition on Human Rights for this fantastic initiative. A time of celebration on the 50th anniversary of Fiji's independence, Fiji Day, but also a very important time to reflect on our past, current situation, and think about where we possibly are going. So electoral systems and constituency or constitutional boundaries are crucial for who ends up ruling the country, who wields power in the country. So in constitutional negotiations, that becomes a central aspect of the willing and dealing that goes on behind the scenes, because it's critical. So in terms of the systems that we have inherited, during the colonial time, as John rightly pointed out, it was based on ethnicity and race, and to a lesser extent, geography. The last election under the colonial setup was in 1966. A lot of seats were communal seats, that is based on ethnicity, but there was also, for the first time, cross-voting seats or national seats, which allowed people from all ethnicities to vote for the same candidates. However, the candidates took up ethnic seats or communal seats. What is interesting about the 1966 general election is that for the first time in Fiji's history, women actually voted. That's 4 years before independence. How ridiculous is that? Secondly, indigenous Fijians also had the franchise for the first time. While there was ethnic Fijian representation in the legislature earlier on, but this was based on a list of names presented by the Great Council of Chiefs to the governor, and the governor then chose their representative. So it's, for me, hard to believe that 4 years before independence, these two categories of people were given the franchise. Post-independence, we have had 10 general elections. These elections have occurred under 4 different constitutions and 4 different electoral systems. Because of the ethnic nature of the voting that took place, often elections and the outcomes were regarded as zero-sum games. Winners took all. And because ethnicity plays such an important role, it was seen always, the governments were always seen as ethnic governments. Who ran the show? Oh, it's a Fijian government or Indian government, etc., etc. And that did not contribute to stability. The 1997 Constitution chose to break that and put in place this power sharing arrangement, which did not work either. Okay, in terms of my own story, it's a long story, I don't want to talk about it. Unlike John, I was always just about an activist. And I actually preferred to just be a fisherman. My family always thought that I'd end up being a fisherman. I don't know how I fell into academia and, all this business of activism. But that's the way things have happened. So I was a member of the Constitutional Boundaries Commission and the Electoral Commission. Appointed in the Constitutional Boundaries Commission in 1998 and the Electoral Commission in 2014. We had 3 Electoral Boundaries Commissioners in 1998. They were Mr. Barry Sweetman, who was chair, Dr. Kesaya Seniloli, and myself. And to be the chair, Barry should had to be an equivalent of a Supreme Court judge, which he was. And we worked very well together in challenging circumstances. Because the 1997 Constitution, which was an amendment of the 1990 Constitution, was actually very different from the 1990 Constitution. And we had to draw boundaries, etc. That was quite a lot different from what was in the 1990 arrangement. So the directives were that each constituency, each electorate should have voters that comprise a good proportion of all the different communities, and that all constitutional boundaries should, all voters in every constitutional boundary, every constituency should have the same weight of voting. And I must confess that that was impossible to do. 2 very important principles. That we should have heterogeneous, multi-ethnic electorates or constituencies, and the voting numbers, the number of voters in each constituency should be about the same. So we can say n number of voters elected this representative and their votes are equal. But because of the ethnic nature of these constituencies and the ethnic nature of the population distribution, we were not able to achieve that completely. And Dr. Seniloli subsequently wrote a paper after the 2006 election, which is titled Male Proportionate Allocation of Constituencies. And it's a very worthwhile paper to read. Male proportion. So the 1998 Constitutional Boundaries Commission had to draw 4 different sets of boundaries for the 71 seats that were to be contested. 23 seats for indigenous Fijians, 19 seats for Indo-Fijians, 3 general elector seats, 1 seat for Rotumans, and 25 open seats. And as John has indicated, the Reeves Commission had recommended that there should be 45 open seats and 25 communal seats as we firmly transitioned away from racial voting. But the Joint Parliamentary Select Committee opted for 45 or 46 communal and 25 open. And the decision of the Constitutional Boundaries Commission was to be final. So whatever we decided about the boundaries, they were writ in stone, could not be challenged in a court of law. 17 of the constituencies were in accordance with the Fijian Affairs Board regulations and followed provincial boundaries. Ba, Tailevu, and the Kandove provinces was split into two because of the size of the population of these provinces. And then for indigenous Fijians, we also had to make 6 urban and peri-urban constituencies. And I mentioned about the business of the number of voters should be about the same for each one of these constituencies. And the direction for us was that the boundaries should follow physical demarcation. That means rivers, tributaries, creeks, ridges and valleys, physical geography, traditional associations that people have about particular districts and provinces, and means of communication, transportation. They shouldn't be too large, too rugged for people to traverse in order to campaign, in order to vote. And then the 25 open seats on the same basis, that they should be equal and they should have a fair representation of all ethnicities. The Constitutional Boundaries Commission was assisted by the cartography section of the Ministry of Lands. And you know, sometimes people have said or have the impression that public servants are lazy, indolent, inefficient. This is far from truth. There are some first-rate public servants, and at that time the cartography map-making section of the Lands Department was superb. The Public Service Commission and the Bureau of Statistics, as well as the government printery, assisted us in terms of the different aspects of the work that we did. Fortunately for us, there was a census in 1996 that provided us with reasonably up-to-date data about the number of people in Fiji who were over 20 years and who could vote. What we found that often the maps that were available to us were out of date in respect to the administrative and physical boundaries, urban-rural divisions, you know, which keeps changing, and so there was some work to be done there. The Boundaries Commission called for submissions over a period of a little more than a month, a little less than a month, and hardly anybody made any submissions. And then we also talked to the residents of Fijian urban villages about whether they wanted to vote on provincial basis or whether they wanted to join other Fijian residents who don't live in these traditional villages. There's a whole lot of confusion around that because, you know, the Fijian Affairs Board and the Itoke administration, they're supposed to know the precise number of villages. But the confusion actually occurs because there is some debate about which is a traditional village and which is an established village. And we never got to the bottom of that. We actually then just resorted to using the provincial boundaries and separately the urban Fijian voter rolls boundaries. Voting was compulsory in the 1997 Constitution. But not all voters registered, which is, you know, quite interesting, you know. So you couldn't avoid not voting, but if you didn't vote, then your name did not come in the voter roll. I said that we never succeeded in providing equality of representation by the boundaries that we drew, because the ethnic distribution in Fiji was and still is very different. Indigenous Fijians are more widely distributed and concentrated in the north and the outer islands and the interior of the country. Indo-Fijians found in large numbers in the Maduata province, in the Western Division, in urban and peri-urban areas. And you can't reconcile that in terms of drawing maps and putting together. So what we found that there were variations in the number of people in each one of those constituencies. And the variations were anywhere between 10% and 20%, depending on whether you're talking about general voters or indigenous Fijians or Indo-Fijians. We also found that we could not equally distribute people along ethnic lines in the open constituencies. So 25 open constituencies, 10 were predominantly Tokay, and 10 were predominantly Indo-Fijian. And 5 had near parity. So one could say, well, it worked out anyway, but that's the way, and we're criticized for that. The boundaries were not changed. We had 2001, 2006 elections, by which time many more people moved to urban and peri-urban areas. Outer islands have become depopulated. Vanuatu is depopulated. More than 80% of the population now reside on Vijay. But the boundaries that we drew in 1998 was used for the 2006 general election, much to the anger of some of the parties who didn't do well. So that's the story about the Constitutional Boundaries Commission. Very quickly, Electoral Commission, 2014, and I was approached by Ayah Syed Qayyum to be in the commission, as were Chen Ban Yang, the chairman, again equivalent to being a Supreme Court judge. Larry Thomas, Father David Arms, very, very wise about electoral systems. Jenny Sito, Alisi Daurewa, James Sawane, who ran a very successful tourism transportation business based in Nandi, and myself. So 6 members and a chair. And we were appointed for 4 years, and we couldn't be candidates, during that time. And then the acting supervisor of elections at that point in time was Mohammad Samim, who had no experience whatsoever in supervising any elections. But he was the acting supervisor of election, and the the Electoral Commission inquired about the appointment of a substantive supervisor of elections. And we went and saw the Minister for Elections, namely Ayah Syed Qayyum, about such an appointment. And he said that, we're waiting for such an appointment, and it will be made fairly quickly. And subsequently, as a fait accompli, Mohammad Samim was appointed. And although we objected, that was of no account. So the Electoral Commission worked with consultants from Australia, New Zealand, and the European Union. And a couple of those people were actually appointed as assistant supervisor of elections. And we also were involved in appointing people to various positions in the electoral Fijian Elections Office, because it was just starting anew. And I've got stories about that. If you ask me, I'll tell you. And most of these vacancies were filled by the time of the elections. Our work basically was to oversee what the supervisor of elections was doing, and as well as the work of the Fijian Elections Office that the supervisor was responsible for. And we advised the supervisor of elections on various issues that arose over the period that we were in the commission. And we liaised with all stakeholders, civil society, NGOs, political parties, media, bus owners, transportation people, all kinds of people who had stake in the election. We very early on opposed elements to the electoral decree and the constitution, including the timelines for the election. Following the rite of election, things moved too rapidly that the Electoral Commission found it difficult to manage the time. And eventually we actually got into trouble because we were given 3 days, stroke 72 hours, to decide on objections relating to candidates nominated by the political parties and independent candidates. And the objections were received. And we were going through these objections. We had to look at those objections according to the law, according to the election laws, according to the electoral decree. And that took time. And in the end, we determined that a Labour Party candidate that was ruled out, of being a candidate was to be reinstated because the ruling by the Supervisor of election was based on grounds that were not validated. Secondly, we upheld the objections relating to one candidate who subsequently won the election and became a minister because the objections were grounded by evidence. But because we were taking our time, in the assumption that the deadline for making the decision was midnight of the 3 days, we got into trouble because the Supervisor of election gave us an ultimatum. He has no right to give us ultimatums. He is supervised by us. We tell him what to do. But he told our chair, if you don't give us the final listing by 4:30 p.m. today, I'm going to read out the roll. Which he did, in violation of those 2 rulings that we're going to make. So subsequent to that, when the public, allocation of the seat numbers, the candidate numbers were being done, none of us turned up to support it because we had no confidence in the role that the Supervisor of elections made. And unfortunately, that actually reinforced the negativity that political parties had towards the Supervisor of election. None of the political parties had confidence in him as an independent person. And I'm afraid that has persisted to this day. It's very, very different from previous Supervisor of elections. All the recommendations that we made to change the timelines, to change provisions relating to political education, etc., were never implemented. And that includes with relation to the NGOs and civil society. And under the 1997 Constitution, even the 1990 Constitution, civil society NGOs could engage in voter education, could hold seminars, could get debates done between political parties and candidates, and all these things, which is part of the build up to the election, educating the public about policies of political parties, about pros and cons of candidates, etc. All of that is provided by the 2013 Constitution and the electoral decree. And shortly after our appointment, we actually objected to these provisions. We appealed to the diplomatic corps, amongst others, to say this is not right. And of course, we were pressured by women's rights movement and others who wanted to encourage more women to participate and engage in the process. But that hasn't been changed up to this day. And of course, the judiciary, and because we are not following absolute confidentiality of what I say, I'll withhold my comments on the judiciary. But the initial action that we took against the supervisor of election, the judge kind of dribbled around and eventually judged in favor of the supervisor of election, saying that we had frustrated the process. But when the Court of Appeal said more than a year later, it actually chastised the supervisor of election and the Solicitor General for what they had done, and said that the Electoral Commission had every right to object to what he had done, and he had no right to do what he had done. But by this time, or then after that decision, the other element regarding the current government is that never take an electoral defeat gracefully. They always respond by saying, we'll appeal against it, which is what Ayaz Sayed Qayyum did. But then they realized it's probably a long process. They just changed the law. So now, the supervisor of election is a member of the Electoral Commission. He is a secretary of the Electoral Commission. He is no longer being overseen and supervised by the Election Commission. And by the 2018 election, we have a completely new Electoral Commission. None of these people have any previous experience whatsoever of elections. And the most experienced person with respect to elections is none other than the supervisor of elections. And there are pros and cons associated with that. I conclude with that.